Howdy folks, Deacon Parsons here. Today's video is male nature and why we need to draft reform legislation. I haven't been making videos lately for a few reasons. Health issues, busy at work, etc. But mostly because I have a difficult time producing content to help support this platform, which is obviously and openly censorious and promoting a Marxist destruction of our society. So what burr got under my saddle to get me in front of the camera today? Well, there are two basic items. First are the political changes taking place in the United States. One of the side effects of the Trump train is that it has replaced swamp rats in legislatures, allowing Trump to replace activist judges with originalists. Our Supreme Court is about to take a hard turn to the right. The absence of hardcore progressive legislators and judges creates the opportunity for the current massive corruption of jurisprudence, including family courts, to be addressed and with any luck rectified. If we can turn the tide in the United States, we can then be a base to export these changes to the rest of the world. The second reason is my faith in male nature. You know, for years we've all talked about female nature and looked at the statistics and agreed that the average man would be crazy to enter a relationship with a woman under the current circumstances. I was recently in a comment thread when those statistics were brought up again, and when I happened to look at the name of the channel, it was Entrepreneurs in Cars. That got me thinking. The statistics on creating a successful new business are as bad, or maybe even worse, than creating a successful marriage. That being the case, why do so many businesses get started? The simple answer is male nature. The most concise way to define male nature is the unofficial model of the United States Marine Corps. Improvise, adapt, and overcome. It is part of male nature to see the world as it is and improvise, adapt, and overcome to move that world in the direction that it should be. This is a constant in human development and the reason most everything that makes life easier or better is created by men. We men corporately have taken the red pill. As a group, we're pretty much through the red pill rage. Almost every man that goes through a divorce will swear off women and decide to go a version of MGTOW monk. We've all said it, but that almost never lasts. That is because it runs counter to men's nature. Most men want to build, to create something that will last, and to pass that something along to the next generation. Women have a biological clock, but men are also biologically driven to leave a strong family behind them. This is Darwinism Biology 101, survival of the fittest in the quest to reproduce. For us to corporately succeed at this, we must overhaul the family courts. To overhaul the family courts, there needs to be legislation. To propose legislation, someone has to create a draft to begin the process. I submit to you that MRAs and MGTOWs are the people most oppressed by the current legal system and are therefore the best able to draw up corrective laws. I'm going to propose two drafts. First, an update of reproductive rights. Secondly, an update of relationship/marriage laws. I will update reproductive rights in this video. An update of relationship laws will be longer and more complex. It will require a second video at the very least. If there are other laws that need updated, or if you have suggestions to these two, please leave them in the comments. Now, for these draft laws to be useful, they must be accessible to the public at large, and that means on the internet. We need a few channels with a sturdy and diverse infrastructure to host and coordinate the project. I am a microscopic YouTuber. I do not have Facebook, Twitter, or other social media accounts. I am basically techno-Amish. This is my cell phone. If you think this project is worthwhile, please forward this video to your preferred large MGTOW or MRA channel and see if they might be willing to be a clearinghouse. Okay, here's my draft to fix the current imbalance in reproductive rights. I call it the Reproductive Rights Equalization Act. And this is my best guess at legalese. I am not an expert in legalese, so this is probably just pigeon legalese, but here we go. Whereas the current state of reproductive rights in, insert jurisdiction here, is an uncoordinated and often contradictory mixture of antiquated, pre-industrial, patriarchal, common, and canon laws, laws that have not fully balanced current legislation and various court precedents, laws that have not incorporated the newest medical and technological options, laws that have not assimilated the vastly different modern social mores, norms, and situations, and have therefore resulted in unjust and unequal protection under the law to citizens, such protection as required by the preamble of the Constitution, the Equal Protection Clause of the 14th Amendment, and simple ethical justice. Therefore, be it resolved that this Act repeals any and all previous statutes, laws, or ordinance on this matter. This Act voids and nullifies any and all previous court precedents on this matter. This Act allows any person in a court-ordered agreement instated before this legislation to sue to amend said agreement to conform with the provisions of this current law. Be it also resolved that the person who provides the egg shall be named the legal biological mother of the child, unless there is a specific law that allows a woman to donate an egg to an infertile couple. However, the biological mother must be named on the birth certificate, and the adoptive mother must file adoption papers with the court, both the biological and adoptive fathers consenting. The person who provides the sperm shall be named the legal biological father of the child, unless there is a specific law that allows a man to donate sperm to an infertile couple/woman. However, the biological father must be named on the birth certificate, and the adoptive father must file adoption papers with the court, both the biological and adoptive mothers consenting. Since medical science can now prove beyond a reasonable doubt the identity of the parents of a child, a DNA test by a reputable laboratory must be performed at every birth, and the results used to complete the birth certificate. The results of that test must be given to the parents and be made public. Since medical science can now prove beyond a reasonable doubt the identity of the parents of a child, no person shall be liable for the care and/or financial maintenance of a child that is not their biological child, unless and until said person freely and explicitly chooses to legally adopt said child. Each parent is responsible for 1/2 of the maintenance of their child and is due equal custody rights to said child, except in cases where egg or sperm donors have completed the legal process of adoption. Neither parent's rights can be abridged, but by parental deficiency proven to a jury of their peers beyond a reasonable doubt in a criminal court of law. The, quote, best interests of the child, unquote, are subordinate to the just interests of the parent and can only be decided by the parents. If the parents cannot agree, or if a court finds compelling reasons to question the decisions of the parents, a jury of their peers must be impaneled to hear the case. In no instance shall a judge, magistrate, law officer, or any other government-appointed entity decide what is in the best interest of the child other than the parents or a jury of their peers. Be it resolved, since advancement in medical science, statutory law, and legal decisions have largely been to the advantage of the mother, justice dictates that equivalent rights, responsibilities, and privileges be afforded to fathers. Where a mother has the legal right to abort a child without the consent of the father, said father can only be held legally liable for 1/2 of the cost of an abortion at the least expensive accessible clinic should the mother decide to not have an abortion. Where a mother has legal access to a morning-after pill or other abortifacient, without consent of the father, Said father can only be held liable for 1/2 the cost of an abortifacient at the least expensive accessible pharmacy should the mother decide to not take said abortifacient. Where a mother has the ability to use a, quote, safe haven, unquote, to relinquish custody, i.e. abandon, a child without legal consequence, the father of said child will have the same time parameters once he has been legally notified of the child's existence to voluntarily relinquish custody of said child with the exact same indemnities afforded the mother. If an unmarried mother decides to put the child up for the adoption, the biological father must first be given the option to accept full custody and keep the child himself. Paternity fraud and/or sperm jacking shall be a felony with a minimum sentence of 5 years and a maximum sentence of 18 years with no statute of limitations. The perpetrator of the fraud will also be required to make restitution up to and including the loss of all rights to the child in question. The court shall take into account the wishes of the victim of this crime and can alter and/or amend punishment with the victim's consent. In any future cases where medical science, technology, and/or legal changes create new options for parents, said options must be applied in such a way that each parent have equivalent practical rights. Okay, here's what I see that needs changed. What did I miss? Again, pass this along to some of the power players in MGTOW and MRA manosphere, and let's see if we can get this train to pull out of the station. Change is coming. Assuming we all survive the November elections and its possible luau fallout, let us be in the position to counterattack the progressive feminist Marxists and take back some ground. Let me know in the comments if you think a reworking of marriage or relationship laws would be useful. This is Deacon Parsons saying, keep your powder dry, love your maker, love your mate, and do what's right because it's right, and devil take the hindmost.